in Article 129, Dr. Ambedkar defined a court of record as the court the records of which are admitted to be of evidentiary value and they are not to be questioned when they are produced before any court. Article 129 further says that the Supreme Court shall have all the powers of such a court, including the power to punish for contempt of itself. Dr. Ambedkar described this power as a necessary consequence from the status of a court as the court of record. Jurisdiction. The Supreme Court of India has three kinds of jurisdiction. Number one, original jurisdiction, appellate jurisdiction, advisory jurisdiction. Original jurisdiction of the Supreme Court. Article 131 deals with the original jurisdiction of the Supreme Court. The Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute. Number A, between the Government of India and one or more state, or number B, between the Government of India and any state or states on one side and one or more other states on the other, or number C, between two or more states. The jurisdiction of the Supreme Court shall not extend to the following matters. Number 1. The dispute arising of a treaty, agreement, covenant, engagement, squad, or other similar instrument which has been entered into executed before the commencement of the Constitution, continue in operation after such commencement, or which provide that the said jurisdiction shall not extend to such dispute. Article 131. Number 2. Under Article 262, Parliament may by law exclude the jurisdiction of the Supreme Court in dispute with respect to use, distribution, and control of the water of any interstate river or river valley. Parliament, under Article 262, may by law exclude the jurisdiction of the Supreme Court in disputes with respect to use of the water, distribution of water, or control of water of any interstate river or river valley. Number 3. The matter referred to the Finance Commission are also excluded from the original jurisdiction of the Supreme Court. Article 280 states that Article 280 of the Indian Constitution states that matter referred to Finance Commission are also excluded from the original jurisdiction of the Supreme Court. Number 4. The adjustment of certain expenses between the Union and the State. Article 290. In the Union of India versus State of Rajasthan 1984 for SCC 238, the Supreme Court has held that a suit for the recovery of damages against the Government of India is not under Article 3 of the Constitution. Article 44, the Constitution 44th Amendment Act 1978 substituted a new Article 139A, which empowers the Supreme Court to transfer cases from any high court to another high court if it is expedient to do so for the ends of the justice. Clause 2 provides that if on the application made by the Attorney General or by a party to any such case, the Supreme Court is satisfied that it involves the question of law or such question as of great importance which is pending before it or before one or more high court, may withdraw the case and dispose it itself. The Constitution 44 Amendment Act 1978 substituted new Article 139A. By 44th Amendment Act 1978, new Article 139A has been substituted, which gives power to the Supreme Court to transfer cases from any high court to another high court if it is expedient to do so for the ends of the justice. Clause 2 provided if on an application made by the Attorney General or by a party to any such case, the Supreme Court is satisfied that it involves the question of law or such question are of general importance which is pending before it or before one or more high court, may withdraw the case and dispose it itself. Article 32 confers original jurisdiction on the Supreme Court whenever there is an infringement of any of the rights conferred to Part 3 of the Constitution, that is fundamental right. The Supreme Court can issue writ for the restoration of fundamental right. These writs may be in the nature of habeas corpus, mandamus, certiorari, quo warranto, and prohibition. Number 2. Appellate jurisdiction. 132 says that an appeal shall lie to the Supreme Court from any judgment, decree, or final order of a high court in the territory of India, whether in a civil, criminal, or other proceeding, if the High Court certifies under Article 134A that the case involves a substantial question of law as to the interpretation of this Constitution. Thus, the appellate jurisdiction of the Supreme Court extends to three branches: civil, criminal, and constitutional. 132 article says that an appeal shall lie to the Supreme Court from any judgment, decree, or final order of a high court in the territory of India. That means a high court has given any judgment, decree, or final order Then, under Article 132, an appeal shall lie to the Supreme Court whether in a civil, criminal, or other proceeding if the High Court certifies that under Article 134A that case involves a substantial question of law as to the interpretation of this constitution. If High Court itself certify that under Article 134A that the case involves a substantial question of law which has to be interpreted by the constitution, which has which substantial question law as to the interpretation of the constitution, then under Article 132 from any judgment, order, or decree of the High Court an appeal shall lie to the Supreme Court. Thus, appellate jurisdiction of the Supreme Court extend to three branches: civil, criminal, and constitutional. Number A, appellate jurisdiction in civil case. Number A, appellate jurisdiction in civil case. Number 1, appeal shall lie to the Supreme Court from any judgment, decree, or final order in a civil proceeding of a High Court in the territory of India if the High Court certifies under Article 134A. Number 1, that it is in the opinion of the High Court that said question needs to be decided by Supreme Court. The 30th Amendment removed the condition of monetary value, that an appeal could go to the Supreme Court only when the amount of value in dispute was not less than 20,000. That means 20 or 20 more than 20,000. Under Article 132, now an appeal will lie in the Supreme Court only if the High Court certifies under the new Article 134A that the case involves a substantial question of general law of general importance. The requirement under the amended article is very strict and both the conditions must be fulfilled. Number B, appellate jurisdiction in criminal cases. According to Article 134, an appeal lie to the Supreme Court from any judgment, final order, or sentence in a criminal proceeding of a High Court in the following ways. Number 1, when a certificate with the High Court, with a certificate of the High Court. Number 2, without a certificate of the High Court. Number 1, with the certificate of the High Court. Under Clause C, an appeal lie to the Supreme Court if the High Court certifies under Article 134A, added by 44th Amendment 1978, that it is a fit case for appeal to the Supreme Court under Article 134 Clause C. Under the new Article 134A, High Court can grant a certificate for appeal to the Supreme Court under Article 132 either on its own motion or an oral application of the aggrieved party immediately after passing the judgment, decree, or final order. Prior to this, the High Court does so only on the application of the aggrieved party. Under new Article 131A, it can now grant a certificate on its own motion if it deems fit. Number 2, with a certificate. Number A, has on appeal reversed an order of acquittal of an accused person and sentenced him to death without a certificate. Appeal can go to Supreme Court. Has withdrawn for trial before itself any case from any court subordinate to its authority and has in trial convicted the accused person and sentenced him to death. But if the High Court has reversed the order of conviction and ordered the acquittal of the accused, no appeal would lie to the Supreme Court. Under Article 134 Clause 2, the Supreme Court has not been constituted as a general court of criminal appeal. It would entertain appeal from the judgment of the High Court only in exceptional circumstances when there is likelihood of injustice to be caused to the party. Sidhweshwar Ganguly versus State of West Bengal, AIR 1958, SC 143. Under Article 134 Clause 2, the Supreme Court does not interfere with concurrent findings of facts unless there is any infirmity. P. Uma Narain versus V.K. Carson, AIR 1971, SC 759. Number C, appellate jurisdiction, constitutional matter. Number C, appellate jurisdiction, constitutional matter. Number 1, an appeal shall lie to the Supreme Court from any judgment, decree, or final order of a High Court in the territory of India, whether in a civil, criminal, or other proceeding, if the High Court certifies that the case involves a substantial question of law as to the interpretation of this Constitution. Where such certificate is given or such leave is granted, any party in the case may appeal to the Supreme Court on the ground that any such question as aforesaid had been wrongly decided with the leave of the court and with the leave of the Supreme Court on any other ground under Article 132. Clause 2 of Article 132 has now omitted by 44th Amendment Act 1978. For the purpose of this article, the expression final order includes an order decided an issue which, if decided in favor of the appellant, would be sufficient for the final disposal of the case. Article 132 states that for the purpose of the for the purpose of this article, the expression final order includes an order deciding an issue which, if decided in favor of the appellant, would be sufficient for the final disposal of the case. Notwithstanding anything contained in this chapter, Supreme Court may in its direct discretion grant special leave to appeal from any judgment, order, decree, determination, sentence in any case or matter passed or made by any court or tribunal in the territory of India. Discretionary power of Supreme Court. The above provision is not applicable to any judgment, determination, sentence or order passed or made by any court or tribunal constituted by law relating to armed forces or under any law relating to armed forces. Article 136. In the Election Commission versus Venkata Rao AIR 1953 Supreme Court 210, it has been held that an appeal from the decision of a single judge will not lie in the Supreme Court. Article 132. Number 3, advisory jurisdiction. Article 143 provides that number 1, if at any time it appears to the President that a question of law or fact has arisen and is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer, that means President may refer the question to that court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion therefrom. Number 2, the President may, notwithstanding anything in the proviso to section 131, refer the dispute of the kind mentioned in the said proviso to the Supreme Court for opinion, and the Supreme Court shall, after such hearing as it thinks fit, report to the President's opinion thereon. The use of the word may in the Article 143 Clause 1 indicates that the Supreme Court is not bound to answer the reference made to it by the President. In the Kerala Education Bill AIR 1958, Supreme Court 956. However, the Supreme Court in Special Court Bill 1978 AIR 1959, Supreme Court 478, has held that the court is obliged to give its opinion under Article 143 of the Constitution. It is not noticeable that advisory opinion of the Supreme Court under Article 143, though entitled to great respect, is not binding on court. This view has now been changed in the case, and Supreme Court expressed the view that the opinion expressed in the exercise of the advisory jurisdiction is binding on all courts. See special reference number 2002 AIR 2003 SC 187. Power of the Supreme Court. The Supreme Court can review its own judgment or order under Article 137. A review will lie in the Supreme Court on number 1, discovery of new or important matters or evidence. Number 2, mistake or error apparent on the face of the record. And number 3, any other sufficient reason. In R.D. Sagar versus V.V. Nagari, AIR 1976, SC 2183, the court pointed out that a judgment of the final court, the judgment of the final court, the judgment of the court is final. A review of such judgment is an exceptional phenomenon, permitted only where there is a grave or glaring error is made out. The law declared by Supreme Court shall be binding on all the courts within the territory of India. Article 14. But the Supreme Court is not bound by its own previous decision. Thus, it is clear that the doctrine of stare decisis is not strictly followed in India. Any decree or order passed by Supreme Court shall be enforceable throughout such territory. Supreme Court may make any order for securing the attendance of any person, the discovery or production of a document itself under Article 142. All authorities, civil or judicial, in the territory of India shall act in aid of the Supreme Court, Article 144. The aforesaid powers are, however, not exhaustive and final. Parliament may by law enlarge the jurisdiction of the powers of this court in respect to any of the matters in the Union list. The Government of India and the Government of any state may by special agreement, if Parliament by law provides, still further enlarge the jurisdiction of the court under Article 138. 139 provides that Parliament may by law confer jurisdiction of the Supreme Court to issue writ and order on matters other than fundamental rights mentioned in Clause 2 of Article 32. According to newly substituted Article 139A, White 44th Amendment Act 1978, the Supreme Court can transfer certain case
Article 139A lays down where the case involves the same or substantially the same question of law pending before the Supreme Court and one or more High Court or before two or more High Court, the Supreme Court is satisfied on its own motion or on application made by the Attorney General of India or by a party to any such case that such question are substantial question of general importance. The Supreme Court may withdraw the case or cases pending before the High Court or High Courts and dispose of all the cases itself. Supreme Court may, if it deem it expedient to do for the end of justice, transfer any case, appeal or other proceeding pending before any High Court to any other High Court. According to Article 140, Parliament may confer supplementary powers necessary for an effective exercise of jurisdiction of the court. Rules making power of Supreme Court. Subject to any law made by the Parliament, Parliament may from time to time with the approval of the President make rules for regulating, that means controlling the practice and procedure of the court. And also the rule as to proceeding in the court under Article 131A, 139A, article as per Article 145. Appointment of officers, servants of the Supreme Court shall be made by Chief Justice of India or other or such other judges or officers of court as he may direct. Article 146. So that's all about this video. If you find it useful, like and subscribe my YouTube channel.